Good evening, everybody.
Good evening, sir.
Good evening after a long time.
Yes, sir.
Thank you. Today, every day the practical knowledge we should have, because every day so many problems are coming to us. Those problems shall be sought out by way of filing suits before the trial court relating to permanent injunction and mandatory injunction is required. One of the problem like this, you see today, if client comes, they are trespassing our properties. So what should I do? Then we have to advise only the permanent injunction, because he is a utterly stranger to the property and coming near our property, trespassing over the property. Therefore, we used to advise him, we have to file a permanent injunction against the party who is obstructing our enjoyment of lawful possession of the property. So this is under section 38 of Specific Relief Act, that is perpetual injunction when to be granted. That is under section 38 of Specific Relief Act. This act is meant for discretionary of the powers, discretionary powers of the judges. And under this act only, the specific, what are the main problems of the individuals comes in the court. Specific Relief Act means not only injunction, but also declaration, but also the agreement to sell. Who is not performing their part of contract, it is also filing the suit. So therefore, under the Specific Relief Act 1963, is discretionary power can be used by the judges. So today's topic is permanent injunction. So one remarkable judgment, kindly maybe note down. ILR 1989 Karnataka 1701. This is, party's name is Sri Gauri Shankara Swamigalu and versus Sri Siddhganga Mutt. This judgment was delivered by Honorable Justice Shyam Sundar. So this case is filed by my senior on behalf of Gauri Shankar Swamigalu. My senior name is B.T. Parsarthi. It is a reported judgment. We are always placing this judgment throughout India. We are placing this judgment for the purpose of getting temporary injunction. Whoever going to object us to enjoy the property, who is lawful owner, how to file a suit before the trial court. That is the case. Now, as per section 38, perpetual injunction, that is ad interim temporary injunction, when shall be granted. So that is the judgment has been delivered in this case. So in this case, some of the points for consideration at page number 19 of this judgment, 19 para. What are the points required for ad interim temporary injunction is this. As it is, first is prima facie case is required. What is meant by prima facie case? To prove that I am the lawful owner. That is, who is going to before the court, he must prove that he is a lawful owner. And prima facie case should be shown to say that the defendant is interfering without authority of law, without title to the property, without right over the property. He is trespassing over the property. That is called prima facie case. We must establish before the court. That is the main ground to grant ad interim temporary injunction. While we are filing the injunction suit, permanently restrain the defendant not to interfere in the suit scheduled property, that is scheduled property purchased by me, and I am enjoying the property. Enjoyment means the property who is having a sale deed, he shall place before the authorities and get the khata. Tax should be paid, and he must be recognized he is a lawful owner. That is called as the sale deed enjoying the suit scheduled property. One thing you remember, the title is not a declared possession. Possession follows the title. Means wherever the vendor handing over possession, he must have a possession and then he delivered at the time of execution of sale deed. So therefore, the sale deed, mere having a sale deed does not mean that he is a lawful owner or lawful having possession and enjoying the property. This proverb always kindly maybe look into. Possession follows the title means he must have a possession as on the date filing of the suit. So possession, how to know? That is called as you must place the document before the municipal authorities and get the khata in your name, and assessment on assessment, the tax going to be collected. That is called possession. Mere having a sale deed, he cannot prove his possession of the property. So therefore, prima facie must be shown with all ingredients, means enjoyment, khata, tax paid receipt, everything is available, then only you can go before the court. One thing. Now next, balance of convenience. Whether the plaintiff who is come before the court, he must show the balance of convenience. How the balance of convenience should be proved before the court. That is called as, now whatever the property I am having, enjoying the property more than 1 year and continuously having by lawful possession, so that balance of convenience the judge is going to look into, and then he is proving that yes, he is having a balance of convenience to grant ad interim temporary injunction. This is the second word is required while granting the temporary injunction, while filing the suit for permanent injunction. Next, irreparable injury and loss going to cause the plaintiff. If the trespasser is not restrained, who is going to cause loss? Whether trespasser means whether he is a defendant in our suit. So therefore, he must establish that they are interfering illegally and unauthorizedly without having right title to the property. That is called irreparable loss going to cause to the plaintiff if ad interim temporary injunction is not granted. So therefore, all these slots has been decided. Example, in this case, that is Siddhganga Mata's case, Mat case, it is a very, very good case for us for taking grant of ad interim temporary injunction. In this case, what happened? You know the Siddhganga Mat situated at Tumkur district. That is Gauri Shankar Swamiji is a Mat Adhikari. He is also one of the Swamiji. Then he has permitted to remain in the Mat more than 10 years. The Swamiji was remain in the Mat. Against the Mat authorities filed a suit stating that I was already permitted in this Mat. Therefore, I am entitled for injunction restraining the Mat, Siddhganga Mat, not to dispossess me, not to put me away from the Mat. Therefore, he filed a suit for permanent injunction. It is went up to the High Court. So, because even though you have been permitted, does not mean that you are having a title to seek for ad interim temporary injunction against the Mat. Mat is meant for the general public at large. So therefore, against the Sri Kumar Swami, he is the head of the Mat, and Matadish, he cannot seek a injunction against the Matadish because who has permitted only for the purpose of performing the puja, to look after the affairs of the Mat. All these things has been permitted does not mean that he is having a lawful owner to seek a permanent injunction against the Mat. So that point was decided in this Mat because prima facie case he cannot claimed because he is a owner or he is having right to remain in the Mat. Balance of convenience is not available to him because he cannot claim as if I am permanently appointed or permanently I reside in the Mat. So therefore, balance of convenience is not in his favor. And because the Mat always bringing so many Swamis to do some part of the work, performing the puja or maintaining the hostel. Likewise, several Swamis are bringing to the Mat does not mean that they are having title to the property. Therefore, injunction cannot be granted against those who are not having lawful ownership. Prima facie case is not made out. Balance of convenience is not available to him, and also the irreparable injury going to cause to him, because in this case irreparable injury going to cause the Mat, not to the who has come before the court without having title, without having permanency in the Mat. Therefore, he is not entitled. That has been. These are the point considered. And lastly, injunction be easily. Kindly maybe look into this temporary injunction shall be granted only with the discretionary power of the court. The judge is having a discretionary power to grant ad interim temporary injunction when the suit has been filed for permanent injunction. So these are the 4 points has been considered in this judgment, and it is a remarkable judgment. All the high courts are following this. These are the slots while considering the ad interim temporary injunction suit against any lawful owner of the property. So these are the terms and conditions delivered in this temporary injunction. My humble request, go through the section 38 of Specific Relief Act. What it says, subject to order, subject to other provisions contained in the or referred in the by the chapter, perpetual injunction may be granted to the plaintiff to prevent the breach of an obligation. Because whatever obligation he is having, that obligation should not be breached by the other person existing in his favor, whether expressly or by implication. You see in this case what happened, how the section 38 is operating to file a permanent injunction is concerned. We must have a expressly or by implication title to the property. When any such obligation arises from the contract, means sale, contract, or anything, court shall guided by the rules and provision contained in the chapter 2 of the Specific Relief Act. When the defendant invades, please note down this 38 clause 3, very, very important to grant the permanent injunction against the defendants. When the defendant invades or threatens to invade the plaintiff's right in or enjoyment of property, the court may grant perpetual injunction following case, namely, where the defendant is a trustee of the property of the plaintiff, where there exists no standard for ascertaining the actual damage caused or likely to be caused by invasion, where invasion in such compensation in money would not be offered advocate relief, where the injunction is necessary to prevent multiplicity of the proceeding. So likewise, section 38 is concerned. Permanent injunction shall be granted wherever the injury caused to the lawful owner, having made out prima facie case, balance of convenience in his favor, and then irreparable injury going to cause And also, these are the provision you should make out the case against the defendant. And one plaint, today one plaint has been filed by the apartment owner, who are they filed suit for injunction against the canteen owner. What he did, he is a tenant of the canteen. He has closed during COVID-19, and he filed a suit against the true owner, who are the apartment owners. They are the true owner of the canteen. He wants to restrain them not to interfere in his possession of the canteen. Canteen was closed more than 8 years back. Without paying any rent, he has put the lock. But still he is claiming the injunction order against the true owner, means rightful owner of the property. So whether the injunction is entitled by him or not, you please note down that being a tenant without paying the rent, already he has violated the rental agreement which is took place between them. Such being the case, he has not come before the court with clean hand. So therefore, suppressing the fact that he has not paid the rent does not mean that he is entitled injunction against the true owner. The second condition, he put the lock and he don't want to pay the rent, and some material is inside. Another application has been filed in his suit saying that I want to take back my all the materials without paying the rent, who has put the lock into the premises. We have not permitted him because we have filed his objection. More than 15 lakhs rupees payable by him for 8 months and withheld our money, and he wants to take back his materials which are worth about 1 lakh or 1.5 lakh, that's all. But he shall be restrained. Whether that application can be allowed during permanent injunction suit, because he has sought for taking his material, he cannot be, because he has suppressed his fact before the court, not approached with a clean hand. It is also main ground to reject those applications. So likewise, the suit shall be prepared, whether prima facie case made out by the plaintiff or not, whether balance of convenience in his favor or not, whether the injury going to be caused to him or not. All these things you should narrate it in the para-wise. First, plaint government, the party's name, the second provision, third is address of the parties, fourth one is title to be explained, how you are owner of the property, and about your suit schedule property you should explain at the bottom. Then cause of action you should mention. We have tried our level best, tried to evict him, but he has not evicted, but he is creating some nuisance to the property. Therefore, permanent injunction is required. Likewise, we have to seek a permanent injunction suit. The prayer should be sought to grant, to pass judgment and decree to grant permanent injunction, restraining the defendant, his agents, servants, any person claiming under him. He shall not be restrained. Any person claimed under him shall be restrained from interfering into the suit schedule property. Second, grant such other relief or reliefs. Third is suit schedule property should be mentioned at the bottom. Then verification, then affidavit, then IA, add interim temporary injunction. We have made out prima facie case, but still he is causing injury. At the instance of him, kindly may be granted add interim temporary injunction pending disposal of the suit. All these facts comes within section 38 of specific relief act. Now, another section kindly may be important is mandatory injunction. To whom you have to seek for mandatory injunction? That is at section 39. I want to read section 39, mandatory injunction. when to prevent the breach of an obligation, it is necessary to compel performance of certain acts which the court is capable of enforcing. The court may in discretion grant an injunction to prevent the breach complained of and also to compel performance of requisite acts. This mandatory injunction always seek against the defendant means section 39. It is always against the officers. Wherever the suit has been filed, directing them to provide electricity, directing them to pass the order, directing them to enforce the order. The court has got power to enforce when the mandatory injunction decree they want to sought for. And another, corporation authorities, illegal construction has been made by the adjacent owner. You want to demolish the structure, only you have to seek mandatory injunction against the defendant, because in violation of sanction plan, he has put up construction. Therefore, mandatory injunction can be granted against the corporation because we cannot demolish the structure. They are lawfully, they want to, it is duty of them. Duty has to be carried out only by way of mandatory injunction. Such mandatory injunction can be granted against the government authorities, against act should be done, act shall be to do by them, then only it is liable to mandatory injunction to be granted by the court. So all these facts, even agricultural land, just example, if you have seen the agricultural lands having badu, that is mud has been put both sides protecting protecting by way of mud. If he has put up that mud, encroaching upon the property, adjacent owner can file to remove that mud because he has encroached by way of putting his mud. So therefore, that is also mandatory injunction against the private party also, it can be granted. So therefore, these two sections, 38 and 39, throughout in my office more than 1,000 cases of permanent injunction only, along with temporary injunction we are seeking against the defendants who are interfering, who are causing hurt to us. So likewise, you have to take advantage of this and perfectly you can do your practice. All these particulars available for you. If you want, come over to my office, collect the drafting, and always my advice is whatever draft you are collecting, you must write first, then you put in a computer system. But directly you should not put in the computer system, but yourself use that practice. First one time you should write a plaint and IA, everything you should write along with the suit. And whatever as per the practical knowledge, whatever requirement available for you, you please come and collect those plaint, those drafting, everything is available in my office. And because you are being a student, you are coming as a lawyer, and tomorrow you must keep your dignity and decorum in the society. That is also my advice to you. Thanking you. If any question, you please ask me, I'll put it. Yes.
Sir,
I think
you briefly touched upon.
Yes.
Sir, you briefly touched upon the agricultural land.
Yeah.
So even in case of inheritance or based Hindu Succession Act, can we bring in this injunction?
Sir, injunction
after,
only for not to alienate, not otherwise, not to alienate the Hindu succession property, that is inherited properties, because no partition was took place among us. Therefore, you have no manner of right to alienate the property. That is ad interim temporary injunction relating to the inheritance properties. And you must seek the comprehensive relief. Direct the this honorable court be pleased to effect the division of 1/4 share among the family members. That should be available. Then only you can seek the ad interim temporary injunction against the, and one thing, because best question you have asked me, against Karta, no injunction can be granted. If Karta of the family, if you deemed him, he is a Karta of our family, you cannot seek any injunction against him. And only you have to seek ancestral property, whether is there any necessity to alienate. Necessity means to perform the marriage, to develop the property, such thing he must show. Therefore, he wants to alienate some inherited property, then he has to prove necessity is there. Then only injunction can be available against Karta also.
Sir, being a elder person, property registered on with his name, and but partially which is in a demand land, he went for an injection, which is temporary. It is
Sir,
cancelled.
only one thing, just you now told you, first line you have told me, if the property is purchased somebody names, that is, it is Benami transaction, means in our family, there is a ancestral family available, but still we want to purchase in the name of earning member of the family, who is available in the earning member because he can get a loan from the, because his security is available before the bank. Therefore, used to purchase the property in his name. And tomorrow we have to prove that as on the date of purchase of the property, whether having a income or not, such income. You see, for example, now I am working more than 10 years in the government. I have earned some money, but whatever the property you have purchased in his name, by investing the family fund, family income, along with his income, you have to, burden lies on you, you have to prove that it is the joint family property. So likewise, your pleading should be available. You have to more cautious about the pleading also. Right, sir.
Okay. No, that time family is in a combined family. After that, for 10 years only, it got separated. Now he is claiming that it is my property.
Yes, therefore you have to prove, you have to file a suit. Now today one thing is happened. Today in my office came to me saying that, sir, we have purchased the property in the name of brother. Brother died, sir. He is married, having 2 kids. Now wife is going before the authorities, claiming that he is my owner. So joint status, joint family must be proved. Then only you go for questioning the claim of partition against that particular property. I have today drafted, I have given, because what happened, widening of the road, that land has been acquired. Now, brothers, missus going and claiming compensation from the land acquisition officer. Therefore, I have filed objection stating that, no, he is a last person, last member of our family, and we have purchased because he was an employee. Now, due to COVID-19, he died. Therefore, it is a joint family property and need not pay the compensation because we are also having right over that. Likewise, today I have put my objection, and tomorrow if the authorities still they want to release the fund, I have to file a suit for partition along with ad interim temporary injunction.
Thank you, sir.
Thank you.
So one quick point on how you define joint family in that case.
Sir, joint family means, you see, total 7 members are there. 3 ladies married and 4 of them, due to some expansion of the family, because married, all of them are married. Due to expansion of the family, other joint families' properties are not divided among us. And tomorrow he is also entitled. When he was in a joint status of the family, so definitely whatever earning we have made, in his name we have brought, that pleading we should be required before the court. It is nothing but joint status only. If other properties are not divided among the joint family.
Thank you, sir.
Welcome, sir. Ladies are not asking any question. Why?
We were listening to you, sir. It was informative.
Thank you. Thank you. And one case note down for ladies is concerned. Ancestral property and joint family properties are entitled for equal share along with male member. That is case of Vinod Sharma versus Rakesh Sharma, reported judgment AIR 2020 SC 3717, page number. Recently, Supreme Court has delivered this judgment, and wherever the ancestral property, wherever the joint family property available, and those properties shall be divided equally as long as the children entitled by them. Because what happened, you know the Kannada proverb, Kotten Kulke Horakke Anteli. That is section 6 was amended in the year 2004. That is with effect from 1/1/2005. Therefore, the Honorable Justice Mr. Kumar, who is retired now, my guru is also, he has guided us, and he passed the judgment in Prakash versus Pulvati case. It is went up to the Supreme Court and decided the fact, yes, by birth itself, the woman is also entitled, because when boy is also marrying, when female member is also marrying, why it should not be difference? Why this difference is available? Therefore, Honorable Supreme Court decided this matter in Vinod Sharma's case. Just now I have given. So therefore, female is also entitled equal say. If anything and ancestral property going to alienate, we can file permanent injunction suit.
Hi, sir. Good evening, sir.
Very good evening. Tell me, madam.
Sir, suppose if the property had already been sold out,
Yes.
ancestors' property.
Just this date is barred, madam. Just you note
Yes,
down date 2012-2004.
Okay, sir.
Prior to 2012-2004, if any alienation made, it cannot be taken into consideration. Afterwards, if he has made, you can ask, you should made him as a party who has purchased the property after 2005, made him as a party, and whatever sale did executed, it is not binding on us and entitled equal share. You can file a suit for partition.
Okay, sir. Okay, sir. Thank you.
Thank
sir.
you. Thank you. So in every week I will come. Yesterday I could not able to attend. No problem. Today I have given to you. You please continue the same. I will give the proper example for each and every section, and practical knowledge is required to everybody. And you note down all these things what I have stated. And I think you note down for temporary injunction. You go through this judgment. That is ILR 1989, Karnataka 1701. There are several judgments. Supreme Court is also gone through, and it has been referred this judgment, our own Honorable High Court judgment. It is remarkable judgment. We are placing before the court and getting ad interim temporary injunction also.
Sir, I have one doubt, sir.
Yes, sir.
Sir, you just mentioned that the date, no, the threshold 20 December 2004.
Yeah.
So suppose later after that date, subsequent to that date, if there is any bona fide purchaser.
Not bona fide until and unless if you are not collected, that is called as nemo dat cohabit, means purchaser must be aware, must you careful to take who are the parties to this family and how they are come over this property, because just you see the father's name is available in revenue record, but without getting their Vamshavraksha, that is genealogy tree, definitely you are scapegoat after this period. It is not bona fide purchaser to deprivation of share to her.
Okay, okay. Sir, Because I've not gone through the judgment. When was the judgment delivered? Was the date?
I
Was the
told
date?
no, I told no. AIR 2020 Supreme Court, page number 3717. 2020, that judgment was delivered.
2020, the judgment was. So that means it is a retrospective thing, right?
Always, sir. The retrospective means from 2005, 1/1/2005.
Correct. So if I have purchased the property in 2006 or 2007, then at that point in time, this
Yes, sir.
precedent-
This
precedent
judgment
was
is not
there.
binding, sir. Section is binding. Section 6 of amended Hindu Succession Act. Hindu
Okay.
Succession
I
Act
get it.
amended on that day.
Yes, sir. Yes, sir. Sorry. Yeah.
But seriously affected Vinod Sharma's case from
Oh.
Supreme Court. We have filed more than 40 cases after this judgment is delivered. All the ladies are coming and fighting their right for us.
Thank you, sir.
Welcome, sir. I think you are sitting and discuss along with you. Come prepare immediately after enrolling as an advocate. You must say that, yes, I know the plaint, I know the written statement, I know the facts of the case, all these things available for you. Be ready. From my college, you should be ready always. And whatever you want, if you collect the material for your sake.
Thank you, sir.
Yes,
sir.
madam. Anything, madam?
Sir, can we have the PPT presentation of the session you have taken? It will
Yeah.
be grateful.
Thank you, thank you. Allah, presentation document, I am giving no all these things. You come and collect my paper, then only you can understand how it has been drafted. Because it is not possible for giving to you, where you are going to put in the computer and always you can't remember. You write it, then definitely you can become a good lawyer. Write first one page, one plaint, one written statement, one petition, one objection. Definitely you can learn something else. If you are putting in computer, that is going up, forgetting, and new again you are printing. It should not be happen. You must write first. First one plaint you should write. Petition you should write. Then only you can understand.
Okay, sir, we'll go through it and come back to you.
Welcome, madam. Thank you.
Okay, thank you.
And basic is whatever you are fighting before the court. Basic is from legal notice. If you have sent that legal notice up to Supreme Court, it will go. So therefore, cleverly you should drop. One notice is drafted today, something changes in your plaint, automatically plaint can be rejected. It should not be happen.
Yes, sir.
Thank you. If you want Kannada, I can Kannada to say everything, but still you are being advocates coming in the society fairly. No problem for that. Thank you. Shall I stop now?
Sure, sir.
Yes, sir.
Thank
It was very informative, sir.
Thank you
you.
so much, sir.
Thank you, sir.
Welcome.
Thank you,
welcome.
sir.
Welcome.
Thank you, sir.
Thank you. Thank you. Thank you.
Thank you, sir. Thank you,
Welcome.
sir.
Welcome.
Thank you.